Aidan Kearney, known as Turtleboy, was the force behind the Free Karen Reed movement. He celebrated her victory, walking down the courthouse steps in front of hundreds of fans and followers. But his legal battles are not done yet, as he was back in court facing his own new charges connected to the Reed trial. Witness intimidation. This just days after Turtleboy spoke to Karen Reed's lead attorney, Alan Jackson, who sounded off on prosecutors. Tonight, we take a listen to Jackson's shocking allegations. In Connecticut, Raul Valle faces murder and assault charges for the May 14, 2022 stabbing death of 17-year-old James McGrath and injuries to 3 others during a chaotic house party brawl. Valle told jurors he acted in terror and panicked after being overwhelmed by the crowd. Prosecutors allege that he returned to the fight armed, lunged purposefully, and stabbed McGrath in the chest, fatally puncturing his heart. And now, all the evidence is in and the arguments have been made, and it's time to hear from the jury. And in Central Florida, accused child molester and murderer Stephan facing a potential death penalty, has gotten a week-long delay in his upcoming sexual assault trial. Could there be a deal in the works for this alleged pervert? Tonight, we have all the latest. I'm Vinnie Politan. Thank you so much for joining us here on Closing Arguments. We have a lot to get to this hour, but let's begin. Like, we right now are in the aftermath of the retrial of the century, the Karen Reed trial, and it was a not guilty verdict, which means it's over, right? Someone gets convicted, it's not really over. There can be appeals, etc. The case sort of lives on. But when someone is found not guilty, it's over. Like, it's done. But if you just went on your phone on social media, you'd think we were still in the middle of the case. I mean, people are still arguing and bringing up issues and going after each other about this case and this story. But trust me, it's over. Now, part of the reason is we're learning a lot more about getting some insight into the case. For instance, Robert Alessi, Dave Yannetti have gone on a podcast tour online. You may have seen them. Those two on that podcast tour, basically talking to different folks, a lot of folks who were pro Karen Reed in their coverage of the case online, but giving, some real insight into their thoughts about the case and some of their strategies, things that you don't normally get. And it's interesting to watch, but each time they reveal something, it creates a little bit of a firestorm online. Alan Jackson now speaking for the first time, and you talk about a little bit of a firestorm, absolutely, from what he is saying. He obviously, Karen Reed's lead attorney, came in from California to represent her in Massachusetts, and he spoke to Turtleboy, Aidan Kearney, who is the one who was really the founder of the Free Karen Reed movement. It was his live streaming, his reporting on the case that garnered all that support and ultimately all that money for Karen Reed's defense. So he spoke with Turtleboy, who has his own charges that he's dealing with. So while he was the one leading the charge for Free Karen Reed and Karen Reed was freed, it looks like the next challenge for Turtleboy will be to free himself from the charges that have come against him. And those charges are, of course, connected to the Karen Reed case, allegations of witness intimidation. And we're going to talk about that. But first, I want to get back to Alan Jackson speaking out. This was fascinating. He spoke with Turtleboy on X, and one of the things he was talking to them about was the prosecutors in the case. So you have Alan Jackson, former prosecutor himself, talking about his opponents, his adversaries from the Karen Reed trial, in which obviously he was victorious. Let's take a listen.
How could these folks, the Laura McLaughlin's and the Adam Lalleys and the Hank Brennans, ever sleep at night thinking they got this right?
Do you think they would have slept well if Karen was convicted?
Oh, all of them. All of them.
You
like a
think so?
baby. But like a baby. Like a baby.
You don't think it would weigh on any of them? Like, really?
No, it's a mental disability. Like they will think of themselves as I'm just doing the job of the prosecutor. I put on the best case that I possibly could, and the jury convicted, and I'm going to sleep like a baby because it wasn't my decision.
Fascinating, right? All right, let's bring in our think tank. Joining us tonight, criminal defense attorney, former prosecutor Al Wunsch III. Also, family law attorney Jennifer Brandt. Not with us, Darnell Crossland. And Al celebrates.
Oh, I'm sorry.
You were on screen when I said that. Okay.
Oh, I'm sorry. I didn't know I was going to be on screen. I apologize.
Yeah, not much.
So let's talk about, let's start with Alan Jackson talking about prosecutors and going after them. What are your thoughts about that, Al?
I think it's horrible. I think it sucks. I think it's a stupid move on his part. It is not professional. He is supposed to be a professional. For him to start saying stuff about prosecutors he'll probably never meet with again since he's in California, I think the gloating is just ridiculous. And you're not supposed to do that. No one does that. They had a job to do. They were doing their job. He has a job to do. He was doing his job. Leave it at that. You don't have to attack them personally. I just find that to be absolutely disgusting. And I would never do that in any case, even if I didn't like my adversary. I'm not going to go on the record and say something nasty about them.
What if you're representing someone who you believe was factually innocent and was found not guilty by the jury? That doesn't change the equation at all?
Not at all, because the bottom line is that the prosecutor believed that they had a case and they went forward with it. Okay? That's their decision. They went forward with it. He won the case. So, that's it. You're done. You were able to beat the defense. You were able to beat the prosecution at the game, and you win. So that's fine. You take your win and you walk off the field. You don't gloat. You don't do a victory lap around the courthouse and, whoop and holler. I mean, that just doesn't work for me. I find it to be tasteless.
Let's take a listen now, again from X, Turtleboy speaking with Alan Jackson. Alan Jackson speaking for the first time, this time talking about the judge, Judge Kearney.
Judge Kearney very specifically was not going to allow us to tell the truth to the jury. The fact that she hid the feds from the jury, not once, 2 times, even after being slapped down by jurors, not slapped down by us. I mean, we were always respectful to her. The jurors said, once we found out that these were feds, why didn't you tell us that? That makes all the world of difference.
Yeah, Jennifer, what are your thoughts there? I mean, that was something we talked about a lot, about the jury not knowing that there was a federal investigation of the investigators, not knowing that the experts from ARCA were part of this case because of the federal investigation. That was hidden from both juries.
Yeah, I mean, I agree with Al. I don't think it's his place to be on a podcast speaking out against the judge. He was victorious. What happened, happened. And you don't really want to get on any kind of social media, podcast, etc., TV, and criticize a judge. There's no purpose to that. He may not have agreed with what she did. That's a different story. But I don't think at this point, when he's already victorious, he's already won. He showed what he could do. I don't think it's really appropriate for him to be on there, criticizing the judge at this point or the prosecutors. I mean, I agree with Al on that. It's like, you can see how invested he was in this case. He really took it on personally, which is good for his client. But on the other hand, he is a professional and you want to keep that professionalism. You really just don't want to get on there and tear up everybody that was involved.
Al, how about the actual decision, though, to not allow the jury to know the truth about where the experts came from, and it misled the jury in the first case? There may not have been a second trial if the jury in the first trial had actually gotten, the truth about where these people came from.
Well, you don't have instant replay in a courtroom. You know, you have it in baseball, you have it in football, you have it in basketball. You don't have it on that. And if anything, the judge was consistent throughout this trial. And really, as a former umpire, I will tell you that consistency is the key. And as long as you know that the judge has been consistent on the calls, then you know where the calls are going to go. And that's all you need. And that's all the judge has to give you is just a consistency. You don't have to agree with it, but she had been consistent throughout this entire process. So what do you?
But is that a good thing?
You're going to get on there?
Is
that a good thing?
If the jury walks away from it misled, is that a good thing to consistently?
It's not misled, okay? It's information that was not allowed in. She deemed it not to be relevant for the purposes of what she believed the case in chief was going to be. That's her decision. That's why she's a judge.
Oh, okay?
I know. She has that opportunity.
But the first jury was very, was a little confused by the whole thing and misled. They thought that the ARCA experts were from some insurance company that never wants to find liability for anyone and are jaded. And it was it would have been very easy to let them know where they came from. They were hired by the feds. Ooh, bingo.
Every decision she had was upheld by the next, the appellate division online.
Yeah, they don't care about the jury either.
She had a perfect record.
Yeah, they don't care about the jury either. Okay, so Aidan Kearney has his own legal troubles. Turtleboy was in court today. It's all about witness intimidation. He is now facing a total of 18 counts. There's two new charges of allegations of witness intimidation, which brings the total up to 10. 3 counts of conspiracy to intimidate, 5 counts of picketing a witness. He also has some assault and wiretap charges involving, I guess, a former girlfriend. They had a bitter breakup. Anyhow, let's take a look at what happened in today's hearing.
Offense 1, charging intimidation of a witness, and offense 2, charging intimidation of a witness. Do you wish to waive the formal reading of these indictments?
Yes.
How do you wish to plead to each of these indictments?
Not here. I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in, and these text messages about and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other, and the content of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor, I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file.
Yeah, I'd give you that. Yeah, was a week enough?
I'd like a little more than that.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement.
These messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has the other civilian that we're talking about, who also recently appeared on national news with other members of her family defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest that they are relatively straightforward, and there's no reason for those to be impounded at this time.
This is fascinating, Jennifer. I'm wondering what prosecutors are thinking here. They're charging someone with witness intimidation. The defense is First Amendment, okay? First Amendment rights. So we've got that. Then you set up the buffer zone in front of the courthouse, right? So you've got the state taking further action to reduce the public's right to free speech. And now we're taking records of a public servant and sealing and impounding them and keeping them away from the public. Is there a little bit of a pattern here taking place in a jurisdiction which has already come under fire for what happened in the Karen Reed case, in which they were unsuccessful? Is it time for them to just cut their losses and walk away from this? Or do you think they're going to continue to fight and try to put Turtleboy in prison and try to keep records from being made public?
It's one of these things where you feel like they keep trying. They keep trying and trying, and yet they're failing. So, the natural response would be, let's just cut our losses and sort of let everything go. The verdict was reached and we can all move on, but it's not. They're not moving on. They're keeping at it, now with Turtleboy, now with the records. It seems like they are just trying to prevent the exercise of free speech, just trying to control information. And it's not a good look, especially now after all that's happened and all that's come out with the police department and the investigation and all of that. So I think they should cut their losses at this point. I don't know what they hope to gain by going after Turtleboy.
Yeah, so Al, this is a case where the same prosecutors who went after Karen Reed are now going after the person who started the Free Karen Reed movement, and Karen Reed was freed by the jury. How on earth do they not look in the mirror and say, Les, it's time to move on?
On the one hand, you have to make sure that your witnesses are not going to be intimidated, that they're not going to be pressured, that they're not going to be subject to scorn and ridicule. But I have to agree, this is overkill. It's ridiculous. Let's end this case, please. I'm tired of it. America's tired of it. Let's move on. It doesn't make any sense to prosecute him on this. She obviously was acquitted by the jury. Okay, I don't see any witness that got up there and said that they were that badly affected or rattled by what he did and what he didn't do. And quite frankly, it's just tiring and boring. Get it over. Just finish this case, move on, and find something else to do with the taxpayers' money.
Two of the newest charges are connected to a surveillance video from a pizzeria that he was caught saying something to the surveillance camera from a public street. Okay. One more update in this case. Sergeant Buchanan has been transferred, apparently. Put this up there as a personnel order. He goes from field services, which I guess is like investigating crimes and testifying in court, to a more administrative role at the Division of Standards and Training. Is this a promotion, Jennifer Brandt? What is going on here? And he's going to be in charge of standards and training. He was the one who was in charge of Proctor. He's now in charge of standards.
Yeah, I don't know what kind of standards he's in charge of, but it doesn't seem like it's a promotion to me. I think it's a demotion, and I think maybe this is, the state trying to rectify some past misdeeds in terms of their investigators and their police department. So it doesn't seem like he's moving up the ladder with this new assignment. I think people heard enough from him and maybe put him in a job where even though it says he's overseeing standards, we don't know what standards they are.
Al, is this like in the 70s cop shows where the cops get really mad when they get put on desk duty? Or in real life, do they like it because, let's be honest, it's safer, and officers put their lives on the line each and every day they go out there. Do they not like desk duty?
Okay, well, first and foremost, police officers, they rotate all the time. So this doesn't necessarily mean he's being put there as a punishment. That's first. Second of all, the only thing you can't grieve in a police department is the power of assignment. The chief has the power to assign you to wherever he wants to assign you, and you cannot grieve that. or file a complaint or anything along those lines. You have to go. Third, when you move to a job like that, that's a steady position. It's usually going to be 8:30 to 4:30 or something along those lines every day, okay? Probably get the weekends off. So in a lot of respects, it's probably something a lot better than being in field work where you're subject to coming in late at night, staying late, and having to work on weekends. He's going to be working steady 9 to 5 or 8:30 to 4:30, and he's got to go, and he can't challenge it because, like I said, power of assignment is sacrosanct in police departments.
All right. Al and Jennifer are going to stay with us, but the big question looming is, will Darnell show up tonight? We shall see. Plus, we are in a verdict watch in the Raul Valle case. We'll give you the latest from the courtroom, plus coming up next hour. Tonight on Vinnie Politan investigates the stunning case of a sheriff shooting a judge in his own chambers. Judge Mullen's dead and Sheriff Mickey Stein's charged with murder. What happened just before the shooting? Tonight, we listen to witnesses who were there when it happened.
Join CourtTV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on CourtTV.
Donna Adelson is facing charges of murder, the death of her former son-in-law.
This is terrible. Now that Donna has turned into a defendant, what's next for the Adelson clan?
The Matriarch Mastermind Murder Trial. Live coverage this August on CourtTV.
Ladies and gentlemen, I did receive a note from you regarding count 1 and the fact that you are deadlocked on count 1 that has been marked as Court Exhibit 7. Look, I recognize that most of you, if not all of you, have never been through this process before. There are numerous exhibits and many days of evidence to consider. I did instruct you to consider all the evidence. By the court's estimate, at the time that we received the note, which was 12:47 p.m., you had been deliberating for just about 2 hours or less. Please remember, each of the 4 counts must be deliberated upon separately. If you would like to deliberate on counts 2, 3, and 4, and then return to count 1, that is fine. At this point, I simply suggest that you continue with your deliberations. You should review the evidence and the position of each juror to determine if any evidence has been overlooked or any juror's position misunderstood with respect to either the evidence or the law. Please continue to discuss and consider the opinions of other jurors. Kindly explain your views and listen to the views of others. Majority, please listen to what the minority has to say. Minority, please listen to what the majority has to say. Ultimately, you will make up your own mind and decide this case based on your own individual judgment and conscience. But at this time, please return to the jury room to continue on with your deliberations. Thank you.
2 hours. It was a 9-day trial. And after 2 hours, we're deadlocked. We're deadlocked. And that's the thing. We don't tell jurors how to deliberate. We give them these very vague instructions because we don't want to impact their thoughts about the case at all. But it kind of leaves them to their own, their own devices here. And I can see how a jury, they don't know what's a long deliberation, what's a short deliberation. 9-day trial, once you get past like 9 hours, it starts to get a little bit long, right? But 2 hours, not long. But for the jury, it might be like, hey, we've been here for like 2 hours already. There's no way we're going to agree on this. And this is the murder charge for Raul Valle, who's claiming self-defense in the Preppy Party murder trial. Let's bring back in our guest, still with me, Al Wunsch III, Jennifer Brandt. And look who's showing up. Criminal defense attorney Darnell Crossland. Darnell, working on island time tonight, apparently, making it a little bit...
Magic 8 Ball was wrong, Vin.
What did it say?
Magic 8 Ball was wrong. Said he wasn't coming.
Okay, he's here, which is great. All right, Darnell, you've had a lot of juries come back. I don't know how quickly it takes them to come back and say not guilty on your winning streak that you're on. But what do you think about a jury coming back after 2 hours? What does it tell you about the jury, if anything?
So everyone looks for something to hang their hat on. So as defense attorneys, we're becoming more and more wrong with our prediction. if the jury's out for a long time, we celebrate because we can at least defer the pain of losing, and we start to tell ourselves, oh, they have to find a lot of things to fight with. So if the longer they're out, that means we gave them something to think about. We're beating the government, we're beating the state. If they come back in 2 hours, we typically think that that's a guilty because there was nothing to fight about. So these are confusing when these come back that quick. But if you listen to the defense attorney, and I know him, I'm in court with him, it's a Connecticut case, I know this guy. What you find is that when he was arguing, he was basically saying, why should you believe these people over here who have now have immunity agreements with the state and not agree with the gentleman who said that he was fighting for his life, the defendant? He said that's what it really comes down to, believing this guy, this guy, or believing these people. And these people have an immunity agreement. So I'm telling you, don't believe any of them. And it's a sad thing because it's dealing with kids and futures. So this jury just took 2 hours, says, get another panel. We're not doing this. We're not going to be the one in between. So that's why they had, it wasn't forensic, it wasn't DNA, it wasn't that type of thing. It was wild kids at a party, and they don't want to have to pick sides.
Yeah, Jennifer Brandt, he did testify in his own defense, which usually you need to do in a self-defense case, but he was the only one with a weapon. He was the only one, he had the knife. And 4 people, 3 of them survived, 1 did not here. Are you surprised the jury came back after just 2 hours saying, hey, we're deadlocked?
Yeah, I'm not surprised that they're deadlocked because I think this is a really tough case. I mean, you're dealing with young kids at a party. People can usually identify with that. Maybe they've had their own kids who've had fights at parties, not with a knife necessarily. And I understand that that is something to be considered. But if you believe him, he said it's what he had available to him. He was trying to fight off these other guys, and unfortunately, this happened, and that he really wasn't intending to kill anybody, or he didn't want to. He was just trying to defend himself. So I think it is a hard case because you do have, different stories, and you're dealing with these young kids at a party. Things can get out of hand. There was a lot of taunting going back and forth during this situation. So it's a tough one. I can see why the jury is having a real hard time with this.
Jury had a look at some of the video from the party, Al. So they've got evidence of what the scene was like. They've got the testimony of 3 of the survivors of this, plus you've got the testimony of the defendant himself. So they really have, I think, compared to most trials we have, they really have a lot of insight into what happened that night. Where do you think the confusion is here?
The confusion, I thought the defense did a wonderful job in his closing. And I think that, pointing out the fact that the guy that gave his client the knife isn't standing any charges, has basically is up there talking about everything because he got an immunity agreement and everything along those lines. And I think that if I was sitting on the jury, I'd be like, well, why is he not involved in this? The kid didn't show up here with a knife. He threw a knife to him and said, hey, you may need this. Why isn't he culpable in any of this going forward? That was my problem with when I was listening to the defense. I was like, wow, you're right. I don't know why we would believe these 4 kids or these kids that are getting getting a deal and not going forward, and especially the one who handed them the knife. So I think that it was a very skillful closing by defense. The only thing I didn't like was that he keeps asking questions to the jury, which I would love to have seen the jurors' faces when he was asking those questions. It's like, well, you heard me when I opened when I did the opening that I said, you're going to have to do this, right? And I really would like to have seen what the jurors their expressions.
Well, you're not going to see it on Court TV, Al. You're not going to see it on Court TV.
I'm just saying, and I know that, but it's fascinating to me that he would ask questions like that to a jury and try to elicit some sort of response and not get a objection or something, or even a caution from the judge. But I think he did a great job, and he showed right there that this kid, if you're going to take him down, take the rest of them down. If they didn't do it, why pick on him? Good job.
Darnell, you're up there in Connecticut, as you mentioned, not a stand your ground state. What is the state of self-defense up there? We know how things go a lot of times down in Florida and other states where you have stand your ground. How about in Connecticut historically? Where are they on self-defense cases?
So good question. And a lot of times we debate this among lawyers all the time in Connecticut, and the conversation always sounds like this: we don't have a self-defense. Oh, we have the best self-defense. And I think it's definitely not stand your grounds. But the way the statute words it, it's almost like it's an affirmative defense. It's almost like you're not entitled to it unless you could prove it. And then the prosecution doesn't have to prove beyond a reasonable doubt that it wasn't self-defense. It sort of flips the burden, if you would. So among academia, we debate whether we have a good self-defense statute because it's not as clear as Florida, but it does exist. But it's almost like you have to fight for it.
Jennifer, where are the sympathies in this case? Everyone is young, but the victims are young, 4 of them. The defendant is young, and the jury knows that if they find him guilty, it's serious, it's a murder charge. How do you think the jury is handling that part of this case?
Well, I think they're clearly struggling with it, which is the reason they came back and said they're deadlocked. There's some people there that are having a pretty hard time. I mean, they can't agree on this. I mean, but you do have to think about the victim in this case, that he was unarmed at the time, you know, allegedly he was backing away. I mean, there's all kinds of discussion, and they've seen some of the video about what really went on. And it's a sad case because obviously this kid, you know, star athlete, he's not coming back. And, you know, now they're deciding the fate of another young man who, you know, as you said, if he's guilty, it's going to be the end, not the end of his life, but, you know, a different
it's a long time.
Than he was. And it's really a hard case because people can identify, probably people that have kids can identify, like, what if this was my kid on either side? So I think these cases are really, really tough.
Vinnie, I might add in this thing, because these are young kids, I think the prosecution messed up, and I know the prosecutor. They should have offered him 20 years. They made it a try that you had to try. They offered him like 40 years.
Yeah, so
it
was a 40-year offer, rejected. All right, everyone stay where you are. When we come back, we heard about a deal for the Idaho 4 killer, shocked us all. Could there be a deal in the works for Stephan Stearns, the man accused of sexually molesting and then murdering Madeline Soto?
I note that Mr. Stearns is not present, and it was my understanding that the defense was not requesting his appearance today, and his appearance with us was waived. Is that correct?
Yes, Judge.
Thank you. All right. It's unusual that the court doesn't defer to a joint motion to continue. Under this case, I'm a little, I need some additional information as to the grounds. Suppose the following. I understand that, number one, this is that the assistant state attorneys are in high demand, and unfortunately they have a lot of cases that are pending. I also am mindful of the fact that the orders on the motion to suppress came out close in time to the pretrial. I'll note that it'll be about 3 full weeks until we selected a jury on this case. Based on those factors, the motion to continue, is going to be denied. I will make concessions to when the trial will begin. I think I'd like to begin jury selection on July 22nd. Potential opening statements would, depending on jury selection, be on the 25th with either the presentation of evidence in an order that accommodates unavailability of witnesses beginning that Friday or on Monday, July 28th.
Okay, that's the judge from the Stephan Stearns trials. The first one is now delayed. Stephan Stearns, you may recall, accused of sexually assaulting, memorializing the sexual assaults of a little girl named Madeline Soto for years on his on his account and ultimately on his phone, then charged with her murder after she went missing and her body was found 20 miles from the home. So he's facing two cases, the sexual assault for everything that was found on his phone that he memorialized in the first trial with a life sentence at the end of that. Then following that, a murder trial, which is followed by a potential death sentence. Okay? That's what he's facing. So he had filed a motion to suppress all the evidence from the cell phone. It was denied. And once it was denied, then the prosecution and defense together were asking for a continuance of that first trial. And I'm thinking, what's going on here? Why all of a sudden do we want to delay? What's going on? Now, the defense knows they have no defense. It's over, right? The only defense was not getting this information in front of the jury. It's getting in front of the jury all the pictures of the defendant and the little girl. Is he working on a deal? Is the state attorney working on a deal with Stephan Stearns? Is that possible? We're going to have another one of these where we use the death penalty as a negotiating tool rather than as a punishment? Let's bring back in our think tank. Al Wants the Third is with us. Jennifer Brandt and Darnell Crossland. Do you smell something funny going on here, Jennifer?
I certainly do, Vinny. I think they're definitely working on a deal because, like you said, he has no defense now. The pictures are out there. We know what he did. It's on his phone. It's memorialized. So what is he going to say? Someone else put them there. They're fake. I mean, there's not much he can say. So, you know, maybe they're working on a deal overall to try to
wrap it all up, right? Wrap up the murder and the years and years and years of sexual assault of this little girl.
Just like we saw in Idaho. I mean, I don't think it's much different. We just saw this happen. It's probably they're taking one out of that playbook and you know, trying to work out a deal for him.
Yeah, I mean, both sides here, Al, were asking for this continuance. You know, it wasn't just the defense, both sides. Usually that, you know, this date has been set. The judge did not give the full continuance. He only gave a week. What are your thoughts about what's going on here? Is it really just time to prepare for this trial?
It's definitely they're coming up with some sort of a universal settlement to this matter. I mean, there's no doubt in my mind that that's what they're doing. If they were not doing that, the prosecution would not be consenting or making a joint application for the extension. Obviously, they don't have a problem putting forward their case in the sexual assault aspect of this. With the phone coming in, I mean, the case is solid. But the question is on the next aspect, the murder case, whether or not, you know, there may be some cause for pause that they may be having, that they're saying, you know what, we can wrap this whole thing up. We can get a guilty plea in both, and then we can move on. So I think that may be the situation in here in this instance.
Darnell, the first charges are a life sentence. I don't know what his defense is. Like, they're going to take the images from his phone and let the jury look at them, and it's a little girl being sexually assaulted, both in still images and videos, and it's his phone, it's his genitalia, and it's a little girl, and it's over the course of years. Life sentence. If he gets an offer of a life sentence or 2 consecutive life sentences, I don't know how he could turn it down. Like, because at the other end is the death sentence. Do you think there is a potential deal at work here?
Well, there's always a potential deal at work. The prosecutions, they never
no, not if
in.
you have a prosecutor who believes in using the death penalty for punishment rather than for a tool.
Well, that's what I'm saying. So a lot of these prosecutors, we've covered this on these shows where the prosecutors will start to negotiate and not man up and take it straight to the gate, as they say. In this particular case, first of all, let's not get confused with a motion to suppress to say that because that was denied, that means everything is coming in. Because you know, as lawyers and you know, as a prosecutor, you have to be able to move evidence in, and that takes some skill in how you move it in, when you move it in. So just because the judge didn't suppress it doesn't mean it's going to be moved in, right? And so when the judge says, listen, it's unusual to deny a joint application for continuance. He said that. He said, but I'm going to do it, and I'll give you some trial concessions later. He's saying that I don't like what's happening here either. we're going to move this thing either to a settlement or we're going to try this case. But I'm not going to have you guys cozying up and doing some things that I don't support. So that's what I got from that. Now, in terms of whether, in fact, there's negotiation here, the death penalty is the ultimate. And a lot of people politically don't like it. Al doesn't like it. So if they can say, hey, you're going to die or you're going to take life in jail, it is a a negotiating tool. And so if they can do a global dispo for the murder and that, one life is one life. These pleas where you have or sentences where you have 10 lives just don't make any sense. You only get one. So a natural life is, if he gets that, that's it. Not the 40 or 60-year life that some state has.
No,
this
is real. You do
over.
the time in Florida. Florida, unlike other states, you do the time. You get the sentence, you're going to do the time. Al, you were scowling, I believe.
No, it's scowling only because this aspect of it, I mean, it is a tool, and it is a tool that should be used effectively. And if you can guarantee that there's going to be no appeals and nothing else down the line, then they've got this man locked up forever. And he's gone, and he's done, okay? It is a worse situation to be sitting in that prison than even a death penalty in some instances, especially when you have that kind of crime against a small child. He's going to be very popular in general population.
Yeah.
So under the circumstances, you know what? I would be, if I was him, I'd be asking for the death penalty rather than living what he's going to be living for the rest of his life.
Jennifer Brandt, I got to give you the last 10 seconds.
Thanks, Vinnie. I don't agree with Al there. I mean, the death penalty is death, and this little girl is never coming back. So, I mean, he can go to prison, and there are people that manage very well, it appears, in prison, and they still have a life, and they still can learn and do things and, create things.
They have good days, they have bad days. Al Wunsch, Darnell Crossland, Jennifer Brandt, thank you so much. Great to have you aboard. When we come back, I'll reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, Kentucky Judge Kevin Mullins was shot on camera by Sheriff Mickey Steins. What did witnesses see in the moments leading up to this shooting? Tonight, we investigate.
Join CourtTV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on CourtTV.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at the big board and what's happening in the world of crime and justice. We've got a sighting of a dad on the run. This is Travis Decker, who was spotted in the Idaho Sawtooth National Forest. $20,000 reward for this man. Had 3 daughters. They are all deceased. 9-year-old, 8-year-old, and 5-year-old daughter, all dead. He is wanted. Here's the sheriff.
Travis, if you're listening, this is your opportunity to turn yourself in. Do the right thing, do what you need to do, and take accountability for your actions. We're not going to go away, we're not going to rest, and we're going to make sure we find you. You will be brought to justice.
All right, if you see him, please don't approach him. Call 911 immediately. Okay. Before we go, please take a look at your television screens. We have a missing child who needs your help. This is 17-year-old Kimberlin Stodghill. Kimberlin is missing out of Cleveland, Ohio. If you see Kimberlin, pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or the Cleveland Police Department in Ohio. Numbers on the screen. Let's get Kimberlin to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.